Hey legal friends, welcome back to my channel. If you've not subscribed, subscribe, turn on notification bell so that you don't miss out on any episode I post. I'll go straight to the point today. I'm not here to waste your time. We'll be looking at the overview of property law practice. I'm sure by now they would have introduced you to the different courses you'll be having. 5 courses in all: criminal litigation, civil litigation, corporate law, property law practice, professional ethics and skills. I hope I'm not too fast, just try to follow along. So we're talking about property law practice. What comes to mind? But if you just want to say property, what comes to mind? When you hear just property, it doesn't just mean one massive structure. It doesn't just mean land. When I talk about property, it could be corporate, it could be incorporate, it could be tangible, intangible, it could be visible, it could be invisible. Your pen, your notes, your phone, your laptop, they are your properties. But here, our focus here, we're looking at landed properties, property law practice, laws governing land ownership in Nigeria. So, what are the methods through which land may be acquired in Nigeria? If you're looking at maybe the olden days, you can be talking about first settlement, deforestation of virgin land, conquest during tribal war. All these ones are not really there again, but just know it for knowledge sake. And in case you are listing out points, it's better to err on the side of surplus. I don't know if you understand that, but when I say that it is better to err on the side of surplus, it means that it's better to know more than not know any of the points at all. That's what I mean. So the other ways, we have customary grant of land, sale of land, gift of land, inheritance, or devolution of land. So what are the types of property transaction, types of dealings of property transaction in Nigeria? We talk about pledge of land. Okay, let me give an example. Pledge of land. Let's say I'm a lender and there's a borrower. So lender is somebody that lends to a borrower, right? So let's say a borrower comes to me now, me being the lender, and says, please, can you give me so amount? Can you give me 100,000 naira, please? I need it so much. I need you to pay for my child's school fees. So please, I'm like, okay, what do you have to give me as security, as loan for that 100,000 that I want to give you? Then you now say, okay, I'll give you that my farmland, that land that is there. Please just help me hold it. Once I pay back, I'll take it back. So that's just what pledge of land is. Just very simple like that. So, but then for you, the person alleging pledge must now establish that they must now establish the following factors: must establish the pledge itself, must establish the parties to the pledge, must establish the witnesses, time and circumstances of the pledge, and they must establish the consideration for the pledge. If you remember contracts, there must be a consideration. Otherwise there's no contract. There must be a consideration. It could be monetary, it could not be monetary. So then one thing that you should note is that in pledge of land, the borrower is not the borrower, that's the person, the pledger, the person giving the land is not transferring ownership to the pledgee. So the borrower now, remember I cited an example between the borrower and myself. So the borrower that is now saying, take my farmland, that's the pledger. He's not giving me ownership to his land. I'm only holding it as security, just like banks now. When you get to mortgages, talk about collateral, all of that. So the pledger that is giving me that is farmland. He's not transferring ownership. He's only giving me so that I will hold on to it. Pending the time, he will pay back. So no matter how long it has been in the possession of the pledgee, which is myself, once the pledger, which is the borrower, returns it, I have no right to still hold on to it. I must give back possession to the pledger. So it should be established that if entered under customary law as well. So the next type of property dealings we'll look at is gift of land. This one, there's no element of bargain, is a gift, but however there are conditions to making this gift of land. There must be intention of the donor is very important. Did the person intend to donate the land to the person, to the donee, that's the person collecting the land? Then has there been a completed act of delivery to the recipients? So there should be intention, and then there should be delivery, and then there should be acceptance. So 3 things there: intention of the donor to give the land, delivery to the donee, to the person that he wants to give the land to, and then acceptance. There must be an acceptance, just like contract as well. So once the donee has accepted it, then that gift is considered to be, complete. The contract, the transaction is considered to be complete. And then once there's acceptance, the donor has no right to revoke it. Once that, because you gifted it, there was intention, there was delivery, and there was acceptance. So there's no right to say, oh, I'm not doing again, oh, give me back my land. So there's a part, you get to a part where they will ask, okay, maybe if or maybe there's a scenario now that, oh, Mr. A gives a land to his wife. However, when they divorce, he now wants to collect back the land because now he's no longer married to her. That's not possible. Once you're giving a gift is a gift. You're not supposed to come and say, okay, give me back, I'm not doing it again. Hope we are following and I'm not so fast. Okay, so the other property dealing, we have leases. We have mortgage and charge of land. I don't want to really go into detail. This is just an overview. We'll look at all of this in the course of other videos I'll be dropping. I don't want to bore you with the real details now. Then we have donation of power. That's also a type of property dealing, donation of power. Then we also have that donation of power. Something that don't worry, it's interesting. Law is interesting. That's one thing you should know. Law is interesting. Just don't be scared. That's what I will tell you. Don't be scared. And that's why it's good you start early. Imagine you're already listening to this now at this stage. Just keep up the pace. That way, you will find out that by the time it's getting close to the bar final, you'll be at peace. You're not rushing to hey, this note from first week, this note from second. Hey, that's where problem used to happen. And the grading system of law school, it's not jokes, it's not play. A person can have 4 A's now, right? And just 1 B plus, not ordinary B. And that person is already on 2-1. A person can have 4 A's and 1 ordinary B. And that person is already on 2-2. So, are you telling me that person is not brilliant? Somebody that had 4 A's, is the person not brilliant? Or even 3 A's and some B's, is the person not brilliant? So you can see how the law school grading system is. You have to be very strategic. Sometimes in law school, it's not about how well you know book, how well you are brilliant. You just have to be very strategic in your reading and trust God. Hold on to God very well. I'm not joking. I'm a testimony to this. To the glory of God. To the glory of God, God gave me, because hey, I was in Yola. I know what I went through. To the glory of God, God gave me a first class. In fact, the tears. I feel it was the tears. I did not cry while in Yola. Everything. I cried everything when I saw my results recently. So please, it's better you start now. Start now. That's number one thing. Start now. Don't pile your notes. Don't pile drafting. Don't keep drafts till you middle of the whole law journey. Don't pile your drafts. Whatever draft that comes with each topic, as you're making notes for it, also be practicing the drafts. By the time you're going back to it, you see that it's coming back to your memory. It will now be easy for you because it's something that you've been rehearsing, that you've been practicing. So then another type of property dealing is the sale, alienation of interest in land. Then what are the applicable laws? Obviously I already said that. What are those laws that govern land property dealings in Nigeria? We have customary law, as the name implies, customary law, Islamic law, case law, received English law. Then under received English law, you can now talk about what received English law, that the not Nigerian law, but we have received them into our own laws. So we can talk about Statute of Fraud Act of 1677. You can talk about Wills Act of 1837. You can talk about Conveyancing Act of 1881. So generally, what are the Nigerian legislation governing property dealings in Nigeria? So we have Constitution, obviously. Number 1, Constitution of the Federal Republic of Nigeria, 1999, particularly in Section 43, Section 44, the section that provides for acquiring property in Nigeria. We have the Land Use Act, obviously, of 1978. Okay, so here now, I have to make mention of the fact that in property law, while you are in exam, they will ask you, okay, what are the Nigerian laws governing property practice or dealings in Nigeria? Please, as you mention the laws, also try to mention the years. So, like I just said now, Land Use Act of 1978. Don't just say Land Use Act. So, for the ones that will not mention in your notes, while making your personal notes, just add it to it. Look for it. Make your personal research and look for it. So, we have the Property and Conveyancing Law of 1959. We have the Illiterate Protection Laws of various states. We have the Land Instrument Preparation Laws of various states. We have the Land Instrument Registration Laws of various states. We have the Stamp Duties Act. We have the Companies and Allied Matters Act of 2020. That comes in where maybe a company wants to engage in property dealing, so the CAMA will have to come in. Then you will look at also Wills Law of the various states. Look at Administration of Estates Law of states, Tenancy Law, of Lagos State, Mortgage and Property Law, Lagos State Land Registration Law of 2015, Lagos State Properties Protection Law of 2016. So what are the benefits of precedents for solicitors drafting of documents? Okay, now, for instance, now, once I'm called to bar and I start getting property dealings, contracts, I have to draft, right? So let's say it's a sale of land I get now. I have to draft a sale of land, showing the parties the agreement and how it's going to be binding on the parties. So if another client should come now, I can easily now refer to the previous document that I've already prepared before and just make adjustments, change the parties, maybe change the consideration. Maybe the first one I did was 150 million. Maybe this one now is 50 million naira. I'll edit it, and put it that way. I'll edit it, tweak it like that, change the parties, where it is situated, that's the location, how many hectares of land, square meter, all of that. So because I already have the draft, I will just play around the one I've had before to make it easy. So what are the benefits of using precedent of those drafts? And one thing about it, let me just quickly mention, is that you have to be very careful when you want to be using those already prepared documents, so that you don't make mistake. If possible, once you work on it, give it to a second person, give it to a third person, a fourth person, to help you go through it. Because sometimes, because you are the one doing it, you might not see errors in what you've done. So by the time you give it to another person, another eye, a third eye, oh, you did it, oh really, let me see, and then you're surprised, how come I didn't see it? So what are the benefits? It saves time. Once you have such thing, it saves time. It saves time. It serves as a source of ideas. So you can just look at it. Oh, how did I do the first one? Oh, I can implement this, I can add this, I can subtract this. Then for consistency and uniformity, personally, I love my work being organized. So for me now, imagine if I have those precedents, it means that I will have one, like my documents, my drafts will be consistent, to be in a consistent manner, in such a way that maybe if my previous clients come across another client that is also my client, and maybe that previous one sees one of the documents given to this current one, that one can easily say, is this also person your lawyer? That kind of thing. So it makes for consistency, it makes for uniformity, makes your work fine and presentable. What are the ethical considerations for solicitors? They would always ask you in bar finals, ask you in law. You cannot escape ethical considerations, cannot escape. So I'll just quickly go over them. To advise the client appropriately according to the applicable law to a given situation. To prepare a document having regard to the applicable law to that document. Throughout his representation of his client, a solicitor should observe and apply the relevant law to a particular situation. Okay, then you should carefully make use of precedent, like I've said. Don't just adopt the whole content and then you forget the important thing, and then it puts you in trouble because your details is going to be there. Oh, prepared by so lawyer, your address, your seal, everything is going to be there. So you be very careful. Then as a lawyer as well, in dealing with properties. You also have to demonstrate expertise and competence in handling particular transaction, not to draft a wrong document. So what are the responsibilities of solicitors in practice of property law? This is where the RPC comes in. Rules of professional conduct for legal practitioners. The one applicable to you now is the 2023 one. I used it last year, so that's what you're going to be using too. Rules of professional conduct for legal practitioners 2023. Before, the previous one had about 54 rules thereabouts. Now 78 rules thereabouts. There was a second part added for the anti-money laundering section and dealings and what have you. So it's something you must know. You have to learn it, and that's why you also need to start now. I cannot, but always you have to always start early, because you have to learn all those sections. You don't know where the questions are coming from. You cannot fully rely on past questions. For my set last year, they changed things. Things did not go as, I won't say it didn't go as planned, but it didn't go the general way. When we even got into school, law school last year, in my campus, the lecturer kept saying, we won't set anything outside what has always been said. Everything you need is in the past question. That was one lecturer said. But guess what? To our greatest surprise, we entered the exam hall, and those things that you wanted to just flip, there are some things that you feel, they are just on the surface. This one cannot come out. It's the one inside, the one that is very deep to you. That's what will come out. So our greatest surprise is those surfaces that were coming out in our exams, those ones that you would easily just flip. And as simple as it is, if you didn't read those surfaces, then unto God. So please start early. Your rules of professional conduct, start early, rehearse them, learn them. Rule 1, Rule 2, Rule 3. They have different parts. Rule 1 to 13 is one part, Rule 14 to about 25 is another part. It goes on like that. General responsibility of a lawyer, this. So please take it seriously. So I'll just quickly go through the responsibility of solicitors. We have Rule 1, talking about general responsibility of a lawyer. We have Rule 3, aiding the unauthorized practice of law. Don't aid somebody, don't aid and abet. Somebody has not been called to bar, but now you that have been called to bar, you want to give your gown to that person to go and enter court, and you yourself, that person has not been called to bar, but because it's your friend or she's your friend, you don't want to say no. Then for the Rule 1, general responsibility of a lawyer, to always uphold the rule of law. We have Rule 9, practicing fees. As a lawyer, to pay your practicing fees. Rule 10, we have seal and stamp. You have to always attach your seal to every document. We have annual practicing certificate. Rule 12, we have Rule 14, dedication and devotion to the cause of a client. We have Rule 15, representing clients within the bounds of the law. We have Rule 16, representing clients competently. Rule 21, withdrawing from employment. Rule 22, so just check, call at client's house or place of business. You're not supposed to go to a client's house or place of business. According to Rule 22, let the client come to your office. To get to a point in rules of professional professional skills, you look at client interview. You are not to be going to your client's house. It's your clients that are supposed to come to you, but except in that rule. Don't make mistake and say section. No, it is rule. When it comes to RPC, it is rule you use, not section. So that rule, it provides that the exception being that for urgent reasons, for special circumstances or urgent reasons, that's when you should go. Then if you can now go further to give an example of these special circumstances, urgent reasons, that maybe the person is elderly and sick, maybe the person is in detention, but always make sure that first of all you mention that only in special circumstances or urgent reasons. That's when you can now say you want to go to a client's house, before you now list the other examples. This was what we were told, and that's what I'm also telling you. I'm not withholding anything from you. I think I've taken time. I'm so sorry, but I'm sure from everything I've said, you already know that I could really not cut out anything. Everything I've said here is very important. So thank you for watching. Don't forget to subscribe, share with your other friends in other campuses. Let it go around. It's going to be very helpful, and God will help you all in Jesus' name. Amen. All right, take care. Have a great day.